Lawrence, good morning.
Good morning, Tutu.
Oh, beautiful. There I am. So is the system okay now, Lawrence?
Yes, I can hear you.
Okay, thank you. Thank you. I think we can get started. I hope all can hear me. Someone to confirm, please.
Teacher, we can hear you.
Okay, thank you so much. Let me acknowledge the presence of the CEO Council of Legal Education, the Director Examinations, and everybody present. Welcome to this year's, the very first online engagement with the 2026 ATP examination candidates. Before we start, I think it is prudent we have an opening prayer so that we can progress quickly. So kindly opening prayer, please. Mercy, kindly.
Let's pray. Father, we thank you for this day that you've granted unto us. Thank you for this meeting that we are having with our stakeholders and our candidates. We commit the meeting unto the able hands. We pray for wisdom and your guidance from beginning to the end. In Jesus' name, amen.
Thank you so much, Mercy. It is now my humble duty and pleasure to ask the members from the Council of Legal Education to do a round of introduction, just your name and the directorate you represent at the Council of Legal Education. So kindly and quickly, the director will introduce himself last. So the members present, kindly.
Good morning. My name is Mercy Otieno from the Examinations Directorate. Thank you.
Caroline.
Good morning.
Caroline. Good morning. Good morning.
Good morning.
Good morning.
Good morning.
Good morning.
My name is Zadok Amboko from Examination Directorate.
Members present, kindly. I think I can also introduce myself. My name is Peter Chirchir from the Examination Directorate. I think at this point we can, I can ask the director to introduce himself and transition so that he welcomes the CEO Council of Legal Education to give his remarks. So kindly welcome Daktari, give your remarks, introduce yourself, give your remarks, and welcome the CEO Council of Legal Education to give his remarks. Welcome, sir.
Morning, colleagues. Thank you for joining us this morning. My name is Felix Odhiambo, and I am happy to have us join into this meeting so that we may begin our engagements with you at this point. Of course, we met a number of you at the beginning of the year on the 29th of January, during the induction session that you had at the school. So as you approach, now that you've started the third term, we are approaching the tail end of your ATP program. And we have exams that are scheduled to run in November, in the month of November 2026, and where most of you will most certainly be candidates. And it is therefore important for us at this point in time to begin having this engagement so that one, we are able to help you understand the process of registration that is pending, and then also to help with a seamless transition, even as you prepare for your exams. So this is an engagement that is born out of the necessity to enable us be able to onboard you successfully for a seamless transition as you plan to sit for your exams and proceed for pupillage sometime from next year. So we are happy to have you, and at the council and the directorate, we are also wishing all of you the very best in your professional engagements and endeavors. And we hope and look forward to receiving you, not just in November with your exams, but even subsequently after exams. We look forward to facilitating your gazettement and ultimate admission as advocates of the High Court of Kenya. So we are very happy, and our role is to purely facilitate you and facilitate all other stakeholders towards certifying you as ready for admission as advocates of the High Court of Kenya. So thank you again, colleagues, for joining in. May I therefore take this opportunity to welcome the CEO, Professor Jack Mwimali, to make his remarks. Thank you so much, and please feel most welcome, Professor. Karibu sana, Professor. The CEO seems to be having a challenge, but I'm sure he will join us as soon as the issue is addressed. Perhaps at this point, allow me to request Mr. Lawrence Njoroge to give a short presentation on the registration process. Then after that, we shall have Mr. Zadok Amboko giving us the next presentation on feedback from examiners. Lawrence, please, the floor is yours as we wait for the CEO.
Thank you, Dr. My name is Lawrence Njoroge from the ACT division. I'm going to make us presentation on the registration process. We have a two-step registration process for the candidates. Kindly allow me to share my screen. I believe you can see my screen, huh?
Yes, Lawrence.
So from the CLE website, I will also share documentation on this. You'll go to the candidate portal. Then after that, as a first-time regular candidate, you'll click here. Then we have pre-registered your numbers. So I have a sample candidate number. After that, you're required to fill in the following details: your surname, ensure that you fill in all your details as instructed there. You fill in your gender, your postal address, your postal code, your town, your county, your nationality, your ID or passport number, your date of birth, so you can be able to select the year that you're born. So for that, you click up there, you can be able to maneuver the year that you're born. So you choose the year that you're born. Then you upload a scanned copy of your national ID or passport. Kindly ensure that this is in PDF format and it's very clear. So you just choose it from your device. Then you take a clear passport photo. So you choose it from the location that you have saved your file. It gives you this feature that allows you to be able to refine the location. Yeah, so that you provide to us a very clear photo of your face. Then you indicate the firm and the class. Then after that, you provide us the details of your next of kin, the relationship, and their contact address. Then you need to indicate whether you're a person living with disability, and it will give you, if you select yes, it gives you additional information of details that you need to provide. And then if you have any special requirements that you'll require the council to provide for you during the exam, like an example is left-handed, expectant mothers, large fonts and all that. So you select, in my case, no, then you go next. Then after that, you select, you start with your high school education. So in this case, KCSE. So you upload, you indicate your mean grade the English, the Swahili, and then you attach the KCSV certificate. So you add the qualification. Then you go down and add the university. So you can be able to preview your certificate. Make sure that you upload a very clear KCP scanned copy of KCPE. Then you go next to university. So you select whether it's a local or foreign university. You get the day that you graduated. Then the serial number of your certificate. Then you pick your certificate. You pick your university that was attended. Then you attach the university certificate. Then you attach a copy of the 4-year transcripts. So you scan all of them in one PDF file and upload them here. Then the admission letter that you got from the Kenya School of KSL, sorry. Then after that, you add. So for the first step of the registration, you'll be required to pay 1,000 shillings for the registration. For this sensitization, I've just set it to 1 shilling. So you just simply click on make payments. It will give you an option of the pay methods that you can use. In my case, I'll just click on M-Pesa. Then it will give you a number. It gives you the option to initiate OTP payment. So you initiate. Then I'll make the payment on my end. 1 minute, I key in the M-Pesa. So you just make the payment. Then after that, you click complete.
Yes.
You give it a minute. You can see it gives you a notification that the payment has been received and recorded on our system. You may now submit your registration. So you just click OK. So you can see your payment has been received and recorded in the system. So you can read the consent here. We have some info on data protection. So you click, I have read and understood and agreed to the complaint, then you submit. So you give it a second also. So once you submit, it notifies you that you have submitted your registration and acknowledgement email has been sent. So from your email, you receive an acknowledgement email. Let me just show you a sample of the email. So you receive an acknowledgement email regarding your ATP application. Sorry for that. You'll receive an email similar to this, showing you that we have received your document upon submission of the examination application. So the email will have content similar to this. So after this, remember this is the first step. So it will take some time, so maybe a day or two, or maybe a week. And then you'll get a confirmation on your email confirming that you have been, your documents have been verified. If there are any issue, you'll get a notification notifying you what could be the issue. If the documents are okay, then you'll get a notification on email on how you can access the candidate portal. It will have your credentials, that's the username and the password. In case of you experience any technical issues, you can be able to write to us on support@cle.org.ke. The same is available on the website, or you can make a call on the following mobile phone numbers, which you'll be able to get assisted on that. So that's basically the application process. That is the application process for the first time registration. We'll also share documentation on this on our social medias and also on the website in case you experience any challenges. So we'll share this documentation on the website. In case you have any questions, any challenges, you can also write to us. We'll be able to assist you for the registration.
Thank you very much,
Thank you,
Lawrence,
Dr.
for the presentation. Maybe the questions will come in at the end. So thank you so much. So that probably at this point in time, allow me to invite Zadok, Mr. Zadok Amboko, to take us to the next stage. Welcome, Zadok.
Hello?
Okay.
Can you hear me?
Yes, Zadok.
Yes, we can hear
Hello,
you.
can you hear me?
Yes.
But I can't hear them. Hello, director, you can hear me, yeah? Hello, director, you can hear me, yeah? Hello, director,
Yes, we can hear you, Zadok.
Okay, thank you. I'm trying to share my presentation. So just give me a minute to do that. Okay, once again, my name is Zadok Amboko, and I'll be taking you through the feedback from examiners. But before I do that, I just wanted to touch on a few things on the examination process. Especially, this will be beneficial for the new students or the new candidates, the 2026 class. So the mandate of the Council of Legal Education is generally to examine the ATP examination, as most of you are aware. And in that regard, then we'll be having our exams in November. Now, when examining, the mandate of council is starts from all the way from setting of the ATP examination to marking, to carrying out remarks or quality assurance processes. And it's important that a student knows those processes that exist, whether it's an appeal process in terms of remark process and stuff like that. So for me today, I will not delve so much into those processes like the process of setting, the process of marking, the process of remarking, but I will dwell so much on after marking. We normally get feedback from our service providers, in this case, our markers. Some of the feedback, we also get it from the moderators or the quality assurance officers. And that is the feedback that I will dwell on today. But even before I do that, it's important for a student to know that at the end of the exam, a student is required to score either a 50%, that's a combination of oral, project, and the sitting exams. So a candidate must score at least a 50% in all the ATP units, be considered to have passed the examination. By now, most of you have already done your orals. Most of you have already done your projects, and it's important to know that your oral and project examination or marks will only cater for the first sitting. So a student who fails to pass in the first sitting will only now resit that unit, and the two components, the oral and project, will not be considered for a final score in that case. Now, it's important to note that from previous statistics, most students, statistics show that they do not perform very well on a receipt because of the missing two components. In most cases, that then tells you that the two components, the receipt and not the receipt, but the oral and the project, are very important components when it comes to computation of the final score. Council, in most cases, council is supposed to at least offer one examination in a year, although for the last few years, we've had at least two examination series, one in April and another in November. So a student may register to sit for these units in either of the examination. It's important to also note that council is a little bit flexible in terms of how many units a student can register. A student can decide if a student is not ready to sit for all the 9 units, a student is not compelled to sit for all of those units. So what a student can do, can register maybe 5 units, sit for those 5, then come in April and register for the remaining units. So council allows for that flexibility to allow students to sit for units that they feel that they are ready to sit for. So I had already mentioned the responsibility of council, which is to register candidates, what Mr. Lawrence has taken you through, to administer the ATP examination, to mark to take you through the quality assurance processes, and that is generally moderation, to process and release the results on time, and also maybe to carry out the appeal processes or review processes involving the remark processes. So allow me not to go through those processes. I think we'll be having another webinar where we'll, I think somewhere in November, where we'll go through all this and also talk about how you're supposed to maybe approach different units. So just give me a minute. I got to the slide on feedback. Okay, so I sat on the examination for the November. So what a student would be expecting, and one of the things that has been addressed by our service providers is a question on instructions. Most students fail because they do not follow, adhere to strict instructions. Each paper has different instructions or different requirements. If you look at, for instance, the paper on the paper ATP 106, that's legal practice management, it has different requirements. For instance, the paper has 7 questions. A student is required to answer 5 questions, but it has the paper has sections. So apart from the compulsory question, a student is supposed also to narrow down and answer at least a question from each section. Now, one of the problems that we examiners have encountered is a situation where in that paper, for instance, a student answers question 1, a student answers a question in the office practice section, HR section, and the student does not answer a question in accounting, commercial accounting. So a student, you find a student has 5 questions, but these 5 questions are only concentrated in 2 sections. The instructions that the examiners have is that they will mark question 1, mark maybe a question in OP, mark a question in HR, mark an extra 1 question, that will take us to 4, but then not mark another question in HR. In that case, then the student will be examined in 4, for 4, the question that will mark will be 4 instead of 5. Yet the student has done 5 questions, but has not adhered to the laid down instructions. Papers like legal writing, for instance, they also have various instructions. Though the instructions are like the others, you answer only 5. But if you look at the questions, also the structure of the questions is a bit different compared to the other papers. Now, another problem when it comes to instruction is where a student, you've been instructed to answer 5 questions, but the student answers 6 questions. Now, the problem with that, with the current booklet that we have, those who've interacted with the examination booklet or the script, the examination booklet, it's unlike what we used to have sometimes back, where we will give you a booklet and you can decide to start with question 5 or either question. The booklet has already arranged the question in a certain order. So in that case, if you answer all questions and you've not given the direction on which question should be examined, the examiner has instructions that the last question has to be cancelled, even not marked, has to be cancelled, and then the first 5 questions will be marked. So it's important that the student adheres to the instructions and only answer the number of questions that are needed. Apart from that, some units have their own uniqueness or have their own requirements. For instance, units like civil, when it comes to issues of amending pleadings, for instance, there are some requirements I think you've learned in class that there are some of those units will require you to carry a red pen to class. So council might not tell you to carry a red pen, but you need to know from your learning in your respective classes to carry some of those instruments that are needed to, for those specific units. Now, some of the areas that have been identified by the service providers on some of the issues on why students do not perform is a failure by candidates to comprehend the basic procedures, ethical issues, drafting techniques and processes. Some of these I'll look at them in depth in the next slides. There's also failure by candidates to interpret the question. This has been a very big issue where students, for instance, you get a question that requires you to maybe address something on, let me pick something on charges in conveyancing, ATP 107. So instead of the student addressing the specific issue that has been asked, the student decides to narrate everything on that particular topic. So what happens is that you leave it now to the marker or to the examiner to start identifying what the student really is communicating. Now, a student is required to respond only to what is being asked. There are situations where students have misread or misunderstood the question, and therefore they end up now giving irrelevant answers. And so it's important for the student. Another problem when it comes to even the issue of interpreting the question, we've seen situations where students, instead of now responding to the issues, the students keep on repeating the facts of the question and therefore does not address the issues in the question. So it's important that you read the question, reread that question before you sit down and answer or give the answers. Now, another thing is that the issue of being analytical or being able to apply. It's important to try and understand that ATP examination, we've moved away from theoretical, just recalling and giving theories like what used to happen at the universities. So in this particular case, we are requiring students to go a little bit higher because even the levels of taxonomy that are tested are a bit higher. For instance, at undergraduate level, you'll find questions that requires you to remember, questions that requires you to recall. For instance, give 5 factors, yeah, or a question on identify 5 circumstances. Now, you might not get such questions in ATP because ATP now will require, for instance, maybe to tell you, for instance, there's a client who is in your farm who's approached you, and this client requires you to, let me say, requires you to advise, and the client will have given you the case, or the client will have given you the facts. Then you, based on that, the facts given, you'll be required to advise that particular client. Now, we've seen, for instance, where, for instance, a student has been told, for instance, advice, and what we've seen, depending on which kind of paper, some students will now decide to write a letter, some students will write an opinion. So it's important that you know, for instance, when you've been called upon to advise, is the paper looking for form or substance? So it's important for the students to be able to distinguish that. So some of the issues that have been identified when it comes, for instance, for the issue of procedural and jurisdictional errors in litigation, the service providers noted that candidates repeatedly struggle with where to file. For instance, some students do not know, for instance, when you've been asked to draft pleadings, and maybe you're drafting a petition or an OS or a chamber summon, some students struggle a lot to identify the relevant court. So it's important when you're revising to also concentrate on especially when you're revising on drafting pleadings or initiating cases, commencement of suits. It's important that a student be very specific on where to file these particular suits. Apart from just where to file, also the right, the right documents. Some students, for instance, where they're supposed to draft an OS, a student will be drafting a chamber summon. In as much as some of them will tell you that we consider a substantive law, we do not consider technicalities or form. It's important at this level for a student to be able to know how do we approach court. So it's important that a student knows, for instance, when do we approach the High Court, or where do we file particular documents and stuff like that. And this one was actually identified so much in civil litigation, ATP 100 and ATP 101, that is criminal litigation. There is also an issue of over-reliance on outdated precedents and irrelevant case law. So it's important that even as you go through, I know some of these things might be a problem of the curriculum design or the syllabus that has not been updated, but it's important that the students update their knowledge. Now, this problem, we encounter it a lot, especially with the students who are reciting the unit. So it's important for those students to update their knowledge and also to update their syllabuses. It's important to note that when the council is setting exams, they request for updated course outlines from the Kenya School of Law. And those are the course syllabuses that we use. So sometimes we find the syllabuses, the case law has already been updated, but the student who went, who is relying on let me say a 2024, 2025 syllabus, is still citing some case law which has already been overturned by the court, or courts have developed new jurisprudence in a particular area, but the student is not aware. So it's important that a student updates himself, especially with emerging jurisprudence in court. So apart from that, also there's an issue of form over substance. Now, here, you need to understand the structure of each paper and the requirements for each paper. You need to understand the requirements for each paper. There's a paper, for instance, let me look at legal writing. And drafting requires some specific, concentration on specific issues. So you might find, for instance, when you're drafting or a student is drafting, there is a style of drafting. When you're drafting, for instance, let me say a legislation, or when you're drafting a policy, because most students have not been performing well when it comes to drafting policies, you need to look at what is required, what is the form, and at the same time, look at the substance that is required to actually come up with that particular policy. So you find some students, for instance, who will give you the format of a particular document that they need to draft, but when you look at the form, when you look at the substance in it, it does not address anything, or it's not close to what the student is supposed to be drafting. So for instance, there's a time when students are drafting a policy, but then they draft a policy as if they are drafting a bill. So up there, the student has identified that this is a education policy. But when you look at even the body, the student has addressed it as if he's drafting a legislation or a bill or something else. So it's important that a student be able to separate that. There are other papers which I talked about earlier, that require, for instance, if civil litigation, if you've been asked amendments, then a student, there's a difference between a student, for instance, who will amend and they also use a red pen and stuff like that, and a student who won't, because there's the issue of red pen, there's the issue of underlying. The other students who can amend, yes, but then fail to use a red pen. Now, what I'm saying is that the student will not lose all their marks, but there has to be distinction between a student who used a red pen or who followed the form, of carrying out the amendments, and a student who did not follow that. So you find maybe if you compare the two students, they did the same thing, but you find one student has maybe 1 or 2 extra marks compared to the other. So it's important that you look at each unit, each ATP unit with their own specific requirements, so that when you're sitting for that paper, you are aware of that. Then I think I've also addressed the issue of document distinctions and drafting deficiencies. Candidates are adept at describing documents theoretically, but fail when asked to draft them. So for instance, even in probate, for a long period of time, we've had very minimal drafting in probate. But if you look at the past papers for the past few years, maybe for the last maybe 2 years, you'll find that there are a number of areas that have been tested, in the drafting areas that have been tested in the probate. So you find, for instance, a student understands what a will is, but the student is unable to draft that will. Or a student understands what, let me say, understands that you're supposed to draft regulations, or you're supposed to draft. A student can identify when you're told, for instance, draft the legislative proposal. A student is able to identify that what is required is an amendment bill, but then a student is unable to draft that particular bill. So the students have to move away from just mere theory to now the application part of it. Then there's the issue of analytical shortfalls and fact reproduction, which I talked about earlier. This is a very serious issue. The use of FIRAC or the use of IRAC when it comes to answering question need to be understood properly. Because what we have seen is a student, instead of applying IRAC properly, what they do, they'll have a whole paragraph of summarizing facts. They'll a whole paragraph or a whole page just summarizing, actually repeating the question. Then after that, you'll find then they'll go down, list all the relevant rules or all the issues, then the rules. Then they have only one paragraph where they're doing analysis. Now, most of the time, you'll find that the examiner will not award you marks for repeating facts, will not award you marks for repeating or giving all those issues, but the examiner will concentrate so much on the application part, the analysis part. So it's important if, for instance, to analyze, and I've been told, for instance, from the fact pattern, advice on 5 issues. What most people or what an examiner requires is for you to get that particular issue and analyze it. Because at the end of the day, facts will come out in your analysis, conclusion will come out in your analysis. So it's important that a student understands that it's not about listing all the facts, listing all the issues, listing all the relevant law, then having one paragraph of analysis. Then you fail to actually understand the application of the FIRAC or IRAC rules. So it's important that during this period of time, as you're revising, to understand how do we use IRAC in answering the questions. So generally, it's an issue of approach to questions. How do you answer questions? Because then you waste a lot of time trying to reproduce facts instead of now dealing with the analysis, dealing with what exactly are you advising on. So it's important that as a student, you narrow down your answers to what exactly is required and you stick to answering the question. Now, in some cases, we'll find a question that requires you to give a yes response or a no response, then you continue now to give your analysis. Some students, I think I might say that the bright students will actually start with analysis before giving a conclusion of whether it's yes or not. In that case, then an examiner will have to read your mind first, or your analysis first, before coming out to your conclusion. There's a danger when you start up with a conclusion. For instance, if the question asked you on a particular area that required a no, and yes, you said yes, that, already you have given an impression to an examiner. Although the examiner will still read through the entire, sometimes it's good to, give that analysis, allow the examiner to read through, and also that analysis should take you to a conclusion. Now, there are a number of papers where students struggle across. There are some papers that borrow from each other. And we've seen this in especially two papers. This is probate and conveyancing, especially on the issue of tenancies, tenancy in common, and joint tenancy. So you might find that because of that cross-cutting, a student sometimes will prepare for probate without considering some of those issues that might arise. So it's important when you're preparing, try also to look at interdisciplinary, look at some of the units that are cross-cutting. Yeah, look at, for instance, probate vis-a-vis maybe the issues of tenancies. Look at, for instance, because sometimes you look at the question, and the question has indicated that the husband and wife were, for instance, own the property jointly or common. And for instance, when it comes to succession, the property will be dealt with differently. So it's important to be able to separate that. And also sometimes you might not find the question in probate, but you might find the question in conveyancing. So it's important that a student, you do not just read probate in isolation for other units. It's important that you read those units, also and refer to the others. For instance, if you look at the issue trial advocacy, you'll find there are some areas that you are taught in trial. Some areas are taught in civil. Issues of demand letters, for instance, issues of affidavits, you find them in either. So it's important that when you're revising, you do not just revise and concentrate on one unit and forget all other units. Now, as I finish, also look at, I think I had already mentioned the issue of practical training and advocacy deficiencies. Especially this one is seen a lot when it comes to the paper that most students, although perform very well, and this is the issue of trial advocacy. Here, students, candidates fail to read instructions to the instructions that have been given to counsel carefully, or they might not understand their roles, especially when it comes to issues to do also with the dispute resolution. For instance, if you are a mediator, what is your role? For instance, I remember in November, there was a question on trial advocacy, but in relation to trial issues in either mediation or arbitration. And that question was one of the most underperformed question, because students did not understand what is the role of a lawyer when it comes to either mediation or alternative dispute resolution. For instance, if you are an arbitrator, what is your role? So in that particular case, you need to also to don't just look at issues, for instance, arbitration or alternative dispute resolution. Don't just look at methods, like don't just understand mediation. Go beyond understanding mediation. Look at the process itself. understand the process of mediation, understand what is the role of a mediator, for instance, in that case. And given a situation or a scenario, then you are able to advise when you have a question on that. For some, let me say maybe the last 3 examination cycles, professional ethics have been a problem, although we've had a greater improvement with the April examination. But for the last April and not but 2025 April and the November 2025, it was the most failed unit. And in that particular case, it's important to understand some of the issues or some of the upcoming issues. Look at jurisprudence on the areas that we talked about in our last webinar, the areas of contempt of court, the issues of practicing certificates and stuff like that. Now, these are an area that has really been affected by also social media and also technology. So you have to start contemplating some of the contemporary issues or some of the contemporary questions that might arise from this particular area. For instance, there are areas that are arising now from the practice of law, or for instance, or having online cases, online court cases, or the issues that are now arising on the use of social media by lawyers and staff. And it's important that as a student, you start now looking at whether some of those issues raise ethical questions that might end up then being examined. So do not just read the notes, but also look at the practice of law as it evolves. So it's important for a student to look at it from a holistic point of view. Now, lastly, I'll address the issue of modern regulatory and statutory updates, which I've already mentioned in terms of the fact that some students lag behind when it comes to updating their knowledge in terms of the changes that have taken place, either legislatively or generally in the practice of law, the environment of practicing law, like what I've mentioned in terms of technology, and also in terms of applying contemporary areas that are coming up. For a long period of time, students have struggled to master issues to do with conversions in conveyancing, issues to do with community land, issues to do with even insolvency, although it's not a new concept, but students have also been a bit difficult to get or to differentiate between corporate insolvency and bankruptcy, because there are 2 different processes. But when you find students answering questions, and instead of now, answering issues to do with corporate insolvency, they mix that with bankruptcy. It's important that you know the concepts as a student, so that when you're applying, you're actually giving the right processes, or you're giving, you're referring to the right thing. Then there's an issue of curriculum, which I've also mentioned earlier. And it's important that as students, sometimes your lecturers might not update the course outline. But sometimes students already know that a particular law has already changed. So it's important that you bring it to your attention of your teachers, because sometimes when lecturers, most of the setters of these papers are people in practice, they are practitioners. And sometimes when they see a particular case in the course outline, and sometimes they raise the issue that this particular case has already been, the case has already been overruled. There's a new precedent in that particular area, yet the course outline has not updated it. It's important that when you come across those, it's important that you also track the ongoings in the courts, so that you update yourself on what is happening in the justice sector, whether be it in a commercial, be it in criminal, be it in civil, or in any other area that you're supposed to look at. So generally, those are some of the issues that have been raised. We might not go into the issues of teaching methodology because these are issues that we address with the Kenya School of Law, and we had a meeting with the Kenya School of Law where we addressed some of these particular issues. And then there is an issue which I also mentioned earlier, the issue on students who are resitting. It's important that if you have friends at Kenya School of Law, kindly look at them, have some group discussions, know the areas that have changed, know the laws that have changed, update yourself in terms of your notes, update your course syllabus and your course content. And I think that will really help you to keep updated and also to know what is required of you as a student. So I think that's what I had for today. The other areas on who sets, who marks, I think we'll address that when we have another webinar in November. Thank you. I hand it back to the director.
Thank you. Thank you very much, Zadok, for your presentation. We're most grateful for the presentation. The CEO is now on call, but before we open the floor for any question from the plenary, allow me to invite the CEO, Professor Jack Mwimali, to give us an address. Prof, you're most welcome.
Thank you, sir. Good afternoon, ladies and gentlemen. I hope I'm audible.
Yes, you are audible, Prof.
Yes.
Am I heard? Okay. I want to take this. There's somebody who is unmuted. I want to take this opportunity to just convey the council's sincere best wishes for the candidates for the November examination. It has become now a routine because we believe that it is in the best interest of both council and the students that we have these interactions that would then facilitate or help you in your preparation for the examinations. There are certain things that happen that sometimes do confuse you. And there are also things that on our end as council, we are required to do in good time to be able to then facilitate the proper examination processes. And therefore, when we have these kinds of meetings and engagements with you, we want to have an opportunity for you to understand what the council does and how we undertake these examination processes from issues of registration, because we have had situations where a person registers or wants to register after the exam has already been set and it has been prepared, and therefore it becomes difficult for the council to be able to address their request. Similarly, there are times a student, a candidate would want to withdraw from an exam when it is a bit too late. We have already prepared the documentation, costs have been incurred, and yet, currently, of course, government is operating on austerity to ensure that the taxpayers' money are utilized well, and therefore, ultimately, then it becomes problematic if we are to set so many papers without people utilizing them. So having a very clear and structured way of engagement, the way we have planned, helps us to convey these to you, but also get feedback from yourselves, because ultimately our work is served when you perform well in the examination. And I want to reiterate what I said when we had an earlier engagement. Council does not take pleasure in students failing. In fact, there have been those concerns that we do fail people. We do not like failing people. We want to guarantee the public that all those who have registered and have gone through the process are actually fit for purpose. They are fit to be advocates, and therefore we want to have that assurance ourselves through this examination process before we convey it to the public. However, if we can have the students who are good and those candidates are able to perform well, even for ourselves, it creates an environment where our work is easier. And therefore, we always wish the performance of the students are up to par. So as you prepare for the exams and as we start this registration process, it's always good for us to have that understanding. And I believe from what you have heard from us, it will help you in your preparation. But we also need that feedback from yourselves so that we know where we can do better. With those remarks, I want to take it back to Daktari so that we can receive any comments or compliments from the candidates. I thank you.
Thank you very much, Prof, for your address and for your highlights. We are most grateful. At this particular point in time, we're supposed to go to a Q&A, but please allow me before we get into Q&A just to restate a few things, a few issues that I think that have come up from in the course of the various presentations that we have had. But one of them has not come up, but it is important that I raise it. In the recent past, Council has witnessed increase in fraudulent forged academic documents. Some candidates submitting forged academic documents for purposes of registration to undertake examination. I need to highlight this because Council undertakes a verification exercise of the documents that all candidates submit. And last year alone, Council received 3 forged academic papers from 3 candidates. And when it gets to that, then it becomes a criminal process. And of course, if by any chance you would have taken any exams, like was the case with these candidates, the results will not be released, they will be cancelled, and the matter is reported to the competent state agencies. And in this particular case, those 3 candidates are now subject to a criminal process. So please, I would wish to urge us to avoid submitting any forged academic papers to facilitate the registration process. Again, the year before, there was also one candidate that was in 2023. There was also a candidate who submitted a forged academic paper, and the matter is presently in court. So really, Council really means well for all of us, but please let us avoid engaging in illegalities, because those of us who may be predisposed towards that end, please, you really don't have to be an advocate if you don't have the minimum qualifications. Just go to school right, and then qualify to be admitted into university, high school, university, and ultimately the Kenya School of Law. You don't have to forge any papers. So please, the verification exercise is very critical and it is being undertaken. So that is important to be brought to our attention. Again, I also need to just restate one point that Zadok has indicated, that there is need for a distinction as we answer questions between the theory, the what of the law, which is what we encountered in the university as students, and at this level, you are being tested on the how of the law. So how to apply the what of the law, the theory of the law that you learned in the university to solve day-to-day problems that clients meet. Because when clients come to you, when you get into this practicing space, clients tell you stories. So out of those stories, you're supposed to, crystallize, distill issues, and be able to help the client solve the problem. You are a legal mechanic. There is therefore need for us to address that, be very clear in that distinction, so that a common question that we keep on receiving even after results are released when candidates come to the offices. One of the questions candidates keep on asking: how is it that we fail ATP exams yet we passed university exams? The main reason or the main explanation is in ability to distinguish between the what of the law, that is the theory of law as you discussed or as you undertook in the university, from the how of the law, which speaks to the clinical nature of the ATP examination processes. So really, colleagues, that would be my urge to you, that between now and the examination time, all of you, by now, we are very clear in our minds, because all of you have academic papers from the university. So the theory of the law, we are not in doubt about you being very clear on that. What the transition that the school is supposed to help you make is a transition from being a lawyer and ultimately walk you through to becoming an advocate. And that transition is with the application of the law to solve day-to-day problems. Yeah, so those are really some of the issues I'd really wanted to highlight. Say for an additional yeah, so for now, allow me, colleagues, to take us through a question and answer session. And I would just raise up your hand. For at the moment, I can see Mr. Kashem Daniel's hand is up. Mr. Kashem Daniel's hand. Kindly, Kashem, please shoot your question. Then we will be able to answer. Kashem? Kashem, please. Kashem Daniel. If Kashem is not there, allow me to ask Mukono Mudoni. I can also see your hand up. Mukono
Hello.
Mudoni, please.
Hello. Am I audible?
Yes, please, you are audible. Proceed.
Perhaps maybe I could first start with advocating for the rest of my cohorts. Quite a number of people were unable to join the link. It says that the meeting is full. I don't know if you're aware of that. A lot of people tried telling you on the chat. But beyond that, I think the most asked question is, when will you be giving the dates for registration and exams? I'm not sure that I still could be heard. Anyone that can hear me, maybe a thumbs up.
Yes, we had you. We had you, Mudoni.
Okay. Yeah, that was it for me.
Thank you so much. Allow me to ask, this is Oguk Charles to come next. Mr. Charles.
Thank you. Thank you. I'm joining my colleague in advocating for myself and the rest. We joined the online platform when the presentation was towards the 20th slide. It's a kind appeal that if the earlier slides could be repeated to us, even in a summary and concise form, to help us here. Also, my question is that I heard you mention that you get the syllabus from Kenya School of Law. But in our Kenya School of Law lecture halls, we are told they get the course outlines and the syllabus from Council for Legal Education. I don't know which one is the truth. Do they get from you or you get from them, so that should inform our credible line of revision? Thank you.
Thank you so much, Charles. Abdulrazak, please.
This is Kashem Daniel. I had a problem unmuting, but it appears my mic
Okay,
now.
okay. Let's go to Kashem, then we come to Abdile. Yes, Kashem, please. Sorry about your challenge.
Thank you for the opportunity. I had 3 concerns. I believe Oguk Charles has addressed one of them. One of them concerns the curriculum, because we have communication. Past students have expressed concerns regarding questions being set outside of the curriculum. And we just needed a double assurance that what we have in the course outline is actually what forms part of the curriculum, and that the questions we're going to come face to face with in November will actually come from what we have in the course outline, and what that is basically what we've done in class. That is the first question. The second one concerns what Mr. Zadok, I believe, addressed when we started, concerning cases that are outdated. And the example that was given there is the Giela case. But what I understand from class is that the principles that are currently in use were decided in that case, meaning that any student who wants to talk about injunction and what you have to prove for an injunction to be granted will not run away from mentioning the Giela case, as much as it is outdated. It is also not possible. It may not be possible for students to make themselves familiar with the cases that are coming, which are contrary to what was decided in Giela. It's a huge. It would be a huge problem. So maybe you would enlighten us further if it would be okay to rely on cases such as Giela, given that the principles that were decided there continue to be in force to date, as much as these are things that happened way back. And then the last concern I had regards drafting, because again, Mr. Zadok, I believe, indicated that people are good in theory, but when it gets to drafting, it becomes a problem. And the example he gave, he relied on a will, for example. But what I have in class is that, wills don't really have one standard form of drafting them. We rely basically on the ingredients, like where you have the wills have been attested to by at least 2 witnesses, then the testator signs those ingredients, and we have a list of them. If you have those ingredients, the will can be valid. Is it that if you have an exam, there would be one format maybe that the students will be tried on, because I can assure you, if we are 2,500 students sitting ATP, you can very easily have 2,500 versions of a will if we had that in an exam. So maybe you can enlighten us further on those three. And those will be my takes. Thank you.
So much, Kashem, for your questions. The same will be addressed shortly. Abdile, are you on the call? Abdile Abdirizak?
Yes, thank you very much for granting me this opportunity. My question is about the answers which a candidate will provide. Let's say that a question is asking for, it has 4 marks, and then as a candidate, you provide 5 answers to that question, but the points that are needed or the marks that it carry are 4. So will the examiner choose the right answers out of the 5 points that I have provided? Or let's say that out of the 5 points that I provided, 4 of them are correct, but there is an incorrect one. So will the incorrect one disqualify the other 3 or 4? So how will the examiner mark in such a scenario? Will the wrong answer that I provided be a burden to me? Will it disqualify the right one? I hope I am making sense to you.
Yes, you are, Abdile. Thank you very much for that. And finally, for this first session, let me see. We seem not to have another hand for now. Maybe at this point, let us just, sorry, there is John Musa and Kibogo Ondieki. Then we close this first phase of question and answer. Then we may have another round. So John Mwasa, sorry, not John Musa. John Mwasa, please.
Oh yeah, hello. Thank you. So I think first, thank you to the council for the session. So I have like 3 questions, but I'll only ask 2. The first one is on the answering of the questions. Say, for instance, in a civil litigation paper, where you're required to draft multiple pleadings. My question is on the header. Say, for instance, I'm drafting a plaint, and because of the time constraints and given the number of questions we're supposed to do I have to repeat Republic of Kenya in this and this court, the parties for each and every document, or I can just state if I did the plaint, the verifying affidavit, and the subsequent documents, I can state same as above, so that we are not repeating the Republic of Kenya thing through all those documents that are going to be drafted. And secondly, I might be wrong, but is it possible that CLE can schedule a student to undertake the exams in 2 examination centers, in the sense that some papers you do in one examination center and then others you do in another? And if that's the case, can that be changed so that students get to do all their papers in a single examination center instead of having to switch between examination centers during the examination period? Thank you.
Thank you so much, Mr. Mwasa, for your questions. They'll be answered shortly. Finally, for this phase, allow me to invite Mr. Ondieki. Kibogo Ondieki, please, if you're on the call.
Thank you, Dr. Please confirm that you can hear me.
Yes, we can hear you, sir.
Asante. Allow me ride on Kashim's first question about the president setting cases. Whereas I agree with what our guest did say about cases, students using cases that are maybe still or overtaken by time. For example, if one was to make use of Hortensia Wanjiku Yawe, when we have MNK versus POM, that could be an issue. But Jela versus Casman Brown, cases as Aden versus Republic, those are really cases that we regard to be a precedent setting, and nothing has been decided by courts that disturbs or unsettles that position. Please come out clear on that, because what our take has been is we can rely and ride on precedent setting cases as opposed to last week's decision by the court, which may not be within our reach. Number two is a request to our guest Zadok. Please again put emphasis on what you said about IRAC and FIRAC. Is it the expectation of the examiner that as advocates to be, not the wakilis now in the context of undergrad studies, that we put emphasis on application, because that is where a solution basically becomes available to a problem that may be said by an examiner. My last aspect to ask is, as relates to different concepts as set, we are aware that you have different examiners who may have different perspectives on different issues in law. Is there a way that you manage or control the extent of discretion that an examiner has, so that we be assured that this is a fairly guarded discretion? Because one can read my response and thinks this is a correct response. Another one reads that response and feels this is not what I believe is correct. I want to give an illustration, a practical one, given what we've noted as interpretation given to Section 3.5 of LSA. Even the courts have different interpretations. Is that the case, so that we are assured that we're going to be assessed on a fairly similar basis as compared to where you have a wide discretion on an examiner to give a mark on what he believes to be the correct response? I thank you.
Thank you so much, Mr. Ondieki, for your questions. Colleagues, permit me to request that we close this first phase of Q&A at that point, and then we respond to the questions that have been raised by colleagues during this session. And then after that, we could have a second round of Q&A to address any other issues that may be pending. I can see Marvin Coril, Moranga Marion have their hands up. Please allow me to request that we have you in the second round of Q&A. Marvin and Moranga Marion, you will be given priority in the second phase of Q&A. I thank you so much. Let me start with Kashim. The issue of, the first thing I think I need to speak to is inability of some students to join, some students who join the link. Really, my apologies about that, but I wasn't aware that the link was full. I can see we are, at some point, we were almost 800, but I was not aware that we had any limitations on capacity. But also in regard to that, I have also learned that there was, I would call it miscommunication, and the school may have misconstrued a letter from CLE. The school created a link and shared it with students. And at some point I was told there were 633 students who had joined that link. My very sincere apologies over that, but it was a the school may have misconstrued the letter from CLE. CLE did not really ask the school to create a link for this. So really, my apologies over that, really, that delay, rather that miscommunication that may have costed some of you the opportunity to log in time. My very sincere apologies on that particular issue. Now, there is a question, maybe I'll respond to the issue of, it's a question that came from Kashem, and it also came in from, I can see it also came in from Oguk. So both Oguk, Charles, and Kashem asked the question of curriculum, course outline, and the like. Now, this is the position. The syllabus is a CLE document. But you see, executing the syllabus is executed through course outlines. Now, so course outline is now at the implementation stage of the syllabus. And implementation is at the teaching level. So the course outlines are developed by the various lecturers of the school. So towards examination setting period, CLE requests for course outlines from the school. So the questions as set, or when the setting is done strictly within the syllabus and course outline. So the position is you cannot and you would not have a question or questions that fall outliers that fall outside the course outline and the syllabus. And of course, I've also had stories, people claiming that there are questions that come from outside the curriculum. Please treat that as a bad rumor. I can assure you from where I sit that the setting is done strictly within the permissible instruments, and the permissible instruments are the syllabus and course outline. So really, there should be no cause for alarm that anybody is ever going to set any questions outside the scope of what you covered during your academic sojourn at the school. So I hope that is put to rest. On the issue of Mr. Book had also, and also the issue had also been raised by Mukono, the issue of joining late and the earlier slides. We may not be able to really summarize at this point, but we may be able to try and see how to probably share the materials so that those colleagues who may have missed out from the earlier presentations for one reason or another can be able to would not be able to lose anything much. So really we'll see how best to address that in conjunction with the school administration. So I hope that handles the issues raised by Oguk Charles. And then Mukono Mudhoni had also raised the issue. Mukono had raised the issue of registration dates. This is going to be communicated. First of all, apologies for the delay. It's only that there has been a system upgrade which took longer than expected. The ERP system, CLE ERP system was being upgraded, the examination module, but we believe that in the course of next week, Council should be able to communicate to you in regard to the registration dates when you are going to start registering. So please permit us to accept apologies for the delay, but give Council in the course of next week, Council should be able to provide communication to you in regard to the issue of registration. And tied to that, again, this is Mukono, is the question of examination dates. I have on good authority, I can confirm to you that examination dates have already been approved by council, and exams colleagues will be running from Thursday, the 12th of November to Tuesday, the 24th of November. So those examination dates have already been approved by council, but formal communication will be done in the normal manner through a general notice, but take it that you will start your exams. If you will be sitting for November exams, your exams will be administered from 12th of November to 24th of November. That has already been approved, and it will be communicated formally. So that also clears the two issues raised by Mudhoni. So Mudhoni Mukono and Guk Charles, all the issues you raised have already been tackled. Before I yield the floor to Mr. Zadok, there was the question of Mr. Abdile. Mr. Abdile's concern was maybe a question requires a candidate to provide maybe 4 points to discuss maybe 4 issues. The candidate provides 5, and out of the 5, maybe 2 of them are wrong and 3 are correct. How do the wrong answers impact upon the correct answers? Mr. Abdullah, what I will tell you is that CLE takes the view that you do not unnecessarily, what do I say? You do not unnecessarily put a candidate to a position of disadvantage. So if a candidate has identified 5, and out of the 5, for example, 2 are wrong and 3 are right, the 2 wrong answers do not negatively impact upon the 3 right answers, so that they kind of invalidate the 2 of the 3, and then the candidate scores 1. The candidate will just be marked right in those 3 correct answers, and the other 2 will just be considered wrong, but they do not have a bearing on, they do not have an impact, a negative impact on the 3 correct answers. So really, that is the position. So you do not unnecessarily unduly, in regard to this context, you do not unduly disadvantage a candidate. Zadok, there was the question of outdated cases. This was coming from Kashem, outdated, and it was a running theme. It was also from Mr. Ondieki and Mr. Ondieki. Yes, so Zadok, please, the issue of precedent setting cases and outdated cases, if you may respond to the issues raised by those different colleagues. Come on board, Zadok, please.
Okay, hi.
Yes, we can hear you.
Okay, now, on this question, let me start with the issue of, I don't know who raised it, but the issue of format, and especially raised the issue on the format of a will and the fact that will states different formats. The answer is that the examiners do not have a specific format, but the problem that we normally have, for instance, if you're looking at, let me say, for instance, issue of capacity, and the students do not is unable to draft, for instance, a clause on capacity. That's where now the problem comes in. The student might know, for instance, that this is what is required, but then in drafting it, putting it down on paper is where now the problem comes in. Now, on the issue, I know a number of students have, candidates have raised the issue of GLA. Now, GLA was just given there as an example, not per se, but there's a case that I remember was cited in professional ethics by so many students, but that case had already been overruled by court. I know, for instance, GLA set out those those principles, but also GLA has been clarified by courts in a number of decisions. So most of the times we might not find students, for instance, addressing, for instance, how the issue of prima facie case has been clarified in a number of decisions. But that's maybe where I was going. Yes, I think somebody has addressed that case, the case of Ndolo Aya case, which I think I mentioned earlier, that a majority of students actually relied so much on that particular case in professional ethics, yet that particular decision has been, I think, either overruled or revised. So it's important. I'm not saying that we don't cite GLA. GLA is still a very important decision, but what we are saying is that GLA has also been clarified in other decisions or Kenyan decisions, and it's important, for instance, in your explanations that you also bring out the Kenyan jurisprudence in as far as those particular cases are concerned. Now, there is a student who wanted us also to clarify on the issue of discretion. I think that is on Diek, who looked at different perspectives in law. Now, it's important to note the process, for instance, of examining, especially when it comes to marking. Markers, when they come on board, one of the things that happen is that they develop the marking scheme. You know, we use conveyor belt marking, where a marker, a particular unit is marked by a panel. So for instance, ATP 105 will have maybe 6 people marking that particular unit, and each question is backed by a different person. So before they start marking, we allow them to develop a marking scheme. Now, we try as much as possible to encourage them to address all possible areas, that are possible, or all possible answers. They have to capture them in the marking scheme. And then they mark we'll give them the set as marking scheme to harmonize. So for instance, there are times, for instance, where interpretations will be different from different markers. They have to capture and agree on how to move as markers so that they do not disadvantage any candidate. Then they'll have to go through the process of marking dummies, and the dummy is a sample script. Generally, it's a live script, it's a candidate script. So they mark that script. Now, the purpose of marking that script is just to appreciate how different students have approached different questions, and see, for instance, whether there is something they might have missed, or generally to see how students also approach different questions. So generally on the issue of discretion, the discretion that the markers have is strictly as per the marking scheme. They're supposed to apply the marking scheme strictly, and it's really guarded in this particular case. On the application of IRAC, I think somebody talked about application of IRAC or FIRAC, and generally on the question of analysis or application. So it's important to note that examinations are normally done under a very, extraneous circumstances, or the environment. Generally, there's too much pressure on the candidate and stuff like that. And also the issue of time. You find, for instance, you have very limited time to answer questions. So it's a waste of time when a student concentrates so much on repeating facts of the questions that are already in the fact pattern. So it's important, in as much as facts will come out in the application or in the analysis, let it come out in the analysis. For instance, you are addressing the issue of prima facie, and generally, as you explain, the fact will come out in the explanation or in the analysis that you are giving out, so that you avoid a situation where you have an entire page of generally regurgitating the facts of the of the question, which will not earn you any mark. That's one thing that we're trying to, so that a student is as precise as possible. Then there was an issue, somebody asked a question on drafting headings in civil litigation, and especially the issue of repeating the issue of Republic of Kenya. This is the first time I've had of that concern from a student. We do not have, currently we do not have any position on whether a student has to, but what I know is that in most cases, students are required to repeat those particular headings because generally an affidavit has to be different from the other stuff. Although you'll find that when it comes to marking, a student will only maybe earn 1 mark if it's a notice of motion or if it's a petition up there, it might not earn a mark on the heading of a supporting affidavit, for instance. But generally, the marks are awarded depending with how the markers and the setters have allocated those particular marks. I think I've answered all my questions. Now, there's one more question maybe in the chat, whether you are expected to answer as an expert. And I've seen that somebody have said that markers are experts. Some of the markers are teachers of law. Actually, a number of them are teachers of law. And therefore, they do not expect a student to answer as an expert. But there are basic things that a student is supposed to know. Yeah, we do not expect you, for instance, to draft perfect pleadings. But there are those, indicators of a pleading that a student has to bring out when drafting. So I think that's should be the position.
Thank you very much, Zadok.
Yes.
Thank you very much. Just picking up from where Zadok has left, I think the position is clearly understands that you are at the ATP level. You are, being processed. You are work in progress. So nobody can rate you like, somebody, an advocate of X number of years. But there must be a very clear distinction between somebody who has undertaken the ATP course and somebody who is fresh from the university. That transition or that distinction is what really determines who is ready for, passes exams and is ready for admission versus somebody who is not ready for admission. So you should be, I would say you should be higher than as a university student, but obviously lower than an advocate in terms of, what is expected of you. So the expectation is lower than that of an advocate, but certainly higher than a student fresh from the university. Yeah, in terms of the issue which Zadok has also spoken to from John Mwasa, answering questions, the header on ATP 100, rather header in drafting questions. There's no formal position, but I would urge us to consider reproducing headers in all your draftings, because it is going to be when Zadok has spoken to the issue of developing the marking scheme. So at the point when markers, you have the setter who produced a marking scheme, the markers will also produce a marking scheme, and then they are harmonized. So they are going to have a deliberation and agree on whether or not the headers will count for something or not, so that they have marks allocated to them or not. So it is safer for you to avoid working on, unnecessary anxiety, placing yourself under unnecessary anxiety. Please, for whatever it is worth, I would urge you to just consider reproducing those headers, however taxing they may be, just consider reproducing them. That way, you are safer than if you don't produce them or you don't reproduce them. I've seen on the chart a colleague has asked the question of funding, that is help. What we have is that I understand there will be no funding this year. And the reason is because the government had put in about 91 million, I understand, and much of that money has been loaned out, but has not been, people have been poor at repaying those loans. So the government's condition has been that there be recovery of those loans to enable other candidates to be able to benefit from the loan scheme. So really, the government has put a freeze on that because of right now about more than 80% of the amount that the government has put in has not been repaid. So the sustainability of the fund is at stake. So this year there will be no HELB funding in that regard. There is a question, this came from John Mwasa as well, and I also see it coming from in the chat box, the question of centers. The question of centers in terms of a candidate being placed in more than one examination center. We would, CLE would have loved that candidates just be placed in really one center. But sometimes it doesn't work that way. What happens is that for each of the 9 units, you have different number of candidates. So different number of candidates. So maybe like ATP 100, for example, you may find you have probably 1,800 candidates. You go to professional ethics, you probably have 2,300. And the process of placing candidates, so that you find, if, for example, assuming now like Kenya School of Law, if Kenya School of Law is going to be a center, which is most likely the case, and Kenya School of Law provides, let's say, 600, a capacity of 600 candidates, seating capacity of 600. So assuming Kenya School of Law has been slotted as center number 1, so center number 1 will take in 600 candidates in civil litigation, but then the first 600 candidates for paper number 2, which is ATP, let's say, assuming it's even ATP 101, criminal litigation, the first 600 candidates in ATP 100 would not necessarily be the first 600 candidates in ATP 101, because some candidates register for different units. And then you also have candidates who are resetting. So because of those dynamics, you then end up in a situation where there's a spillover, and then candidates end up being in different centers. But as much as possible, a great many times, it's usually probably on a maximum of 2 centers. So maybe you will find, if assuming cooperative university will be a center, so you find a candidate who probably some exams they may have in cooperative, and then some they may have at Kenya School of Law. And then you will have some of them who would be in Kenya School of Law may have some exams at JKUAT Law School. So really, those are logistical issues that arise because of the difference in the number of candidates who sit, or rather who register for each of the units. Being sat for in any given examination cycle. So that is what causes that that change. And then there is also another issue I need to speak to, the issue of spacing of exams. I see it coming from a number of candidates. We hear you, we really understand your predicament, but it is not very easy for that. You know, what happens is that if exams was to be spaced that way, and at least at some point it was, I understand around 2014, 15, 16, around that time, it was spaced so that you have one exam paper today, then you have a break in between, then you have the next examination paper. Now, that would require that the examinations go for 3 weeks. But that has a cost implication. It has a cost implication because it means council will require a higher budget to hire examination centers, a higher budget to pay for service providers like invigilators, because even if you don't deploy invigilators on a particular day, you have engaged them for that duration of time. So for those 3 weeks, they will be paid. So really, it then comes with, those hidden costs, which have serious budgetary implications, and that will have a bearing in terms of the cost of the examination, the costing per unit. And so because of that, a decision was made that the exams be, the examination, timelines revert back to what it was in those prior years, from 2008 when the current ATP program was launched until around 2013. So really, that is the reason as to why the spacing, there would be no spacing, and the timelines, examination timelines that council has approved for this year, this financial year, do not have a provision for the spacing. So really, we understand your predicament, but council's hands are tied by those, external, extraneous factors, which really council has no control over. And of course, like the CEO had also pointed out, the issue about austerity measures that the government is implementing may really not make it possible to implement. So I think with that, we really have spoken to all the questions and issues that were raised in the first phase of question and answer. Even I'm also looking at the questions that came in from the chats, and a number of them have been addressed, through the first phase of Q&A. So permit me, colleagues, then to maybe just we go back to the second and final Q&A session, which should be very short so that we are able to conclude the exercise. I had promised Marvin Corril, and who was the second? So let me start with Marvin Corril, so that for this second round. So Marvin, please, if you are on the call, kindly unmute and shoot your question.
Yes, thank you very much, Daktari. I don't know if you can hear me clearly.
Yes, we can hear you.
Thank you very much. I just have my question, you have addressed it. I wanted to really confirm about how the school, if it's the school or the council that allocates the centers, and how it's factoring, if it can be done also as per the convenience of students, given that especially online students might, some of them are not in Nairobi, have to travel, come look for a place. So maybe I thought, I don't know if you can also address that, if it's possible that at least the school has data of where the residents of the students are, so that it can help them as they allocate centers, so that a person really doesn't have to travel, let's say, double the distance that another student is traveling for to reach his exam centers or her exam centers. I don't know how possible is that, but it's something you would love to maybe comment on. I would appreciate. Then secondly, you have acknowledged that most questions that have been asked on the chat box have been addressed, but I still think there's some, maybe as you continue taking the question, you could be noting, or one of you could be noting those that have not been addressed in the chat box, so that they are also addressed. Then finally, I'll pick one on the issue of the dress code. I know we have been told that any formal dress code or will be allowed, but I really needed clarity on the same, if it's some, so that I don't come with maybe semi-casual on an exam date, then I'm turned away because maybe it was not clear from the council. For some of us really I wouldn't prefer to have a suit for 2 weeks doing all the exams. It's a very tough place to be. in a suit sometimes. It's not, but you would have to maybe comment on that. I would appreciate. Thank you very much for the opportunity.
So much, Marvin, for the issues raised. They're going to be addressed shortly. I can see Kevin Kiplangat, you also have your hand up. So kindly unmute and shoot your question, please.
Okay, thank you. Mine basically is not a question. It's a request to the council. We keep mentioning about this unit is the most failed, most performed, and to give suggestions. Now, a request to you, if it's possible, you can share with us the marking schemes for these units, because it beats logic that at this point of time, a lecturer, for example, teaching professional ethics doesn't have a marking scheme for the same. So that is a request. And I think it's possible. If, for example, you have the soft copies of the marking schemes, you can actually share with us so that we can look at what the markers or the council wanted from the candidates, and also allow us, the candidates, to adjust the way we are answering these questions, because we can't just be saying, for example, professional ethics is most failed, then the reason we give reasons, candidates didn't answer this question the way it was expected from them, and we keep it at there. We can now go to the next step of share with us the marking schemes, we look at them, then we can adjust. Thank you. And I will be happy to receive the marking schemes from the council, because why not? You have capacity. Thank you.
Very much, Marvin, for your question, or rather your request. I can see Gata Kameri.
Thank you, Doc.
Sorry.
Yes, it's Gataka. Thank you. Now, just to reiterate what Kevin has said, yes, I think we also need to understand where the flaws are, and the lecturers who are taking us through, who are actually the ones polishing us and training us for the exams, should also be able to give us appropriate feedback and align in the way they teach, so that we understand how to tackle the questions. But even well at it, I think over and above, as much as we are digesting the legal content, there should also be a time frame where now we are better trained on how to approach CLE questions, because I feel like answering 5 questions in 3 hours, and sometimes 3 questions are demanding drafting. And of course, these questions, again, are scenario questions that you really have to read through to understand the fact patterns. Then it becomes a challenge by the time, and I think this is why most candidates end up drafting the wrong thing, because there's the interest of time, there's the interest of understanding the fact pattern, and then there's the interest of understanding what the fact pattern demands, and then now drafting or tackling the question. And considering 5 questions in 3 hours, that is a bit, would be a bit too much. So we need to understand how to tackle that, and how to just understand and frame a few things, the do's, the don'ts. Sometimes a candidate might sit too much on a certain draft. How much of that draft is enough for CLE or for the markers? And then how brief or elaborate should us as the candidates be on certain questions? We also need to understand that depending on the fact pattern, of course we are revising on the past papers, but you find a past paper demands a lot. The ones we've been going through, they have a lot of demand. So we need to understand on how CLE would really have us digest the question and be able to dissect and give the appropriate answers, and especially on drafting. Then the other thing I would want to know is, does CLE really conduct a survey on the setters and markers to see if certain sets of setters or markers really expose certain units or candidates to failure, so to speak, because in my opinion, I feel like there's a discrepancy between CLE, KSL, setters, markers, of course, the students. There's a lot of in between, and the more in betweens, of course, the more the discrepancies. Although you have clarified on how the setters and the markers arrive at certain things, and even the dummy marking schemes and dummy marking sessions and all that, then there should be a point where then the candidates get some sort of leniency. So I would really request that maybe CLE could invite former setters, former markers, just to give us a bearing on what really could be expected of candidates. Thank you.
Thank you very much, Mary, for your comments and issues raised. Looks like everyone, rather we don't have any other person with their hands. Oh, there's Kageni Catherine. Kageni, please. Catherine Kageni, please. She might have accidentally tapped onto her mic. Her hand is up, but she's not speaking. Let me go to Vera Cherotich. Vera?
Yes, thank you. I just have two questions.
Sorry. Okay, do I wait for Vera to finish?
Kageni, let's have Vera. Vera is already on the floor. We can come back to you kindly.
Okay, thank you. I just wanted to ask, maybe this had been said earlier, but you've shared the examination dates to be 12th November to 24th November. I also wanted to ask, will we get the examination timetable, and how soon or how late will we receive it, to know which exam will be done on which date, which paper will be done on which date? And then my second question is, with regard to the venue allocation, you shared that candidates might end up being in different centers. So how will a candidate know which venue they've been allocated? Will this be on the exam card on which venue you've been allocated, as well as the date for the exam and where it will be sat? Yeah, so the two questions: exam timetable, and will the venue be on the exam card for the candidate to know which center they will be at? Thank you.
Thank you so much, Vera. And finally, Kageni Catherine, if you are on call, kindly come on board.
All right, good afternoon. I hope you can hear me now.
Yes, we can hear you.
All right, thank you. So I'm just joining up with my colleagues who are asking that with the marking scheme, if indeed CLE does not aim to cause us to fail, I think it would be a show of goodwill to have the marking schemes, and also to have all those past papers readily available on their website. It doesn't really hurt. Then the second thing is the issue of a difference in the national ID and in the school ID. So like in my case, I'm married. So I have the three names, which are my maiden names, that are on my ID for school. And then in addition, I have my married name. So I have four names on my national ID. Of course, the school ID shows the ID number, my national ID number. So I'm just wondering whether there'll be a problem with that. In terms of if I use the two documents to identify myself, will I need to get an affidavit, or will it be okay? Thank you.
Much, Kageni, for your questions. Let me just extend it to two people. Moranga Marion is back. She was among the people whom we had locked out during the first Q&A. So I would wish to request that we accommodate her, and then I can see Kashem is back, but Kashem, you can't have a second bite at the pie. Let's, because of time constraints, Kashem, then there's Kashem and Mudoni. The two of you have already made your points previously. Please allow me just to ask Moranga Marion first, and then Daisy Neta second. Then we just close this. So Moranga, please.
Good afternoon, Dr. Felix and everyone. So my question is, we have a lot of past papers, and I really don't think it's possible for us to go through all the past papers. So I would kindly ask you to please suggest from which years should we start revising from, so that we can effectively prepare for the examination. Thank you.
For your question, and finally, let me ask Daisy Neta.
Good afternoon, Dr. Felix. Mine is very brief. I just wanted to request that if maybe we could have, especially for the recent exams, the 2026 April 1 and 2025, if we could have both the least performed and the highest performed answer sheets, like actually from the students, so that even if we don't get the marking scheme, we can be able to know how the students answered the questions, what they got wrong and what they got right, kindly.
Thank you so much, Neta. Allow me to terminate at that point. There are three things I want to try to get. The question by on different zone of names, coordination, and school ID. Let me ask Mr. Peter to answer that. Mr. Chair.
Thank you. Thank you, Dr. In such cases, we handle them on the ground on a case by case basis. Based on the candidate's scenario, it would be possible to quickly corroborate the information because KSL ID contains the national ID number. So I wouldn't think that such can present an impossibility. Thank you.
Then there is the two questions by Vera Charotich, which you should also answer to. Vera asks, will there be a timetable to specify which candidates are to have which those days between 12th and 24th of November, and where do they get information about venue and location? If you could just respond to those two, Mr. Chair.
Okay, thank you. Sorry for missing that bit. Once the notice to register for the November examinations is out, as an attendant document, we'll also share guidelines. And part of the information in the guidelines is actually the examination timetable. So that is coming in due course once we are set to go. Secondly, the examination card will clearly state the examination center and even the examination room for each candidate. So that should not be a problem at all. Thank you.
Thank you very much, Mr. Chair, for your responses. Let me express the concern that maybe they were. Is there any recommendation in terms of what is the scope and determine really
Excuse me, Dr.
limit.
You're breaking
Daktari, apologies.
You're breaking
Sorry,
a lot.
how is it now?
Sorry, we can't hear you. You're
Much
breaking
better.
up.
I think you need to switch your network. It's come back again.
Okay. Let me pass log in. Mr. Churchill, you could try to log in.
Terry, I seem to have lost you.
Now, as we wait for Daktari to come back, there was a question on there was a question on whether CLA has done a survey on examiners and setters and whether some setters expose students to fail. Now, we need also to understand that the process of setting involves very many people, very many setters. So once those setters come on board, you'll find that one unit has around 5.
Hello, everyone. Can I be heard?
Yes,
Now
no,
you
you're clear.
can.
Okay, thank you so much. Thank you so much for the feedback. I was addressing the issue that has been raised, the issue that was raised by Marion Moranga, the question about past papers. Really, Marion, I wouldn't be able to say with certainty about, tell you that please maybe focus on past papers from 2020 to 2026. I wouldn't really want to present that position. And my advice has always been, your primary reference or your primary revision point should not be about past papers. It should be about the scope of the syllabus and the course outline. Then you revise based on the scoping as has been determined by those two instruments. Reason is, even if you take past papers from, let's say, 2015 until now, it's 2015 when CLE came into existence and started took over the examination function, until now, there is chance that maybe in some units, there could be some topics that may not have been set, or some aspects of the syllabus that may not have been tested for the entire period of time. So do not constrain yourself purely to revision of past papers. So your revision should be informed fundamentally by the scope of the syllabus, and the revision is to supplement or complement rather that your preparation. So that really is what I would say in regard to your inquiry. Daisy addressed the issue of the worst and best performed papers. I understand that CLE used to do this, but then there were concerns were raised, especially in light of Data Protection Act of 2019, that may have implications on data protection, obligations. So there are discussions still going on in that regard. And once council makes a definitive decision in that regard, then council will provide a way forward in terms of whether that practice may be reactivated or not. So really, it is about the reason as to why that stopped and probably it continues to stop for now is because of council is still exploring the full length and breadth of whether or not this practice has a bearing on its obligations under the Data Protection Act 2019. So for now, that may not be, for this year perhaps, it may not be possible. So until after council will have made a decision in that regard. So Marion, Daisy, Vera, and Catherine, Kageni has an issue that touches on what somebody else had also mentioned. There was Marvin. Marvin had spoken about, had raised the issue of dress code. The fact is, colleagues, you don't have to be in a formal attire for the examination. A smart casual would be sufficient. But if you choose to be in formal attire, well and good. As of now, there is no requirement that you be formally dressed. So if that position was to change, it will be communicated. But as of now, smart casual still does it. So you don't have to really suit yourself up for the entire period of time, examination period. Now, Marvin had also raised the issue of examination centers, and especially in light of the fact that there are candidates who have been taking their their classes online, and therefore the issue of convenience comes in. Now, council would have really loved to really accommodate all candidates and the convenience that that would come with examination venues, but it is also constrained. Most candidates, I would tell you, most candidates prefer to take the exams from Kenya School of Law, and usually we get overwhelmed with requests that come from candidates requiring that they take exams from Kenya School of Law. But then the school only has so much capacity. And also, I need also to point out that there are also other considerations. For example, the school also is the center, the official center for all candidates living with disability as well as those with special needs. So because of that, the number of candidates living with disability as well as candidates with special needs already eats into the capacity of that center, examination center. So there can only be so many students, candidates who can be accommodated at Kenya School of Law. So much as council would have loved to address that, right now its circumstances are constrained. However, council is exploring the possibility of redesigning the system such that based on a candidate's preference and the question of when they apply for examination, then now they would be placed in those particular centers subject to availability of space. But that is still being explored because there are other considerations that have to come into place. But for now, candidates are placed by the system based on, and usually for like assuming we would have exams administered at cooperative, and if cooperative university, if it is let's say slotted to be center number 1, then the system arranges candidates based on their registration numbers with the earliest. So if you are, for example, somebody from, let's say 2011, maybe 2011 0048 of 2011. Now, if that is the candidate with the oldest registration number, that will be candidate number 1. So the system will, determine 600 candidates, assuming that center can take in 600 candidates. So it takes in 600 candidates and places them at cooperative. Maybe if Kenya School of Law will declare capacity of 600 again, the next 600 are taken to Kenya School of Law. So those are the dynamics, but council is exploring what reforms or what other ways it can be done to try and, as much as possible, accommodate candidates based on their convenience. But again, that comes with the limitations of lack of internal capacity. Council has to hire all from other service providers, institutions rather. So Marvin Correll's 2 questions have been addressed. The question or issue raised by Kevin, unit most failed, best performed, ties in with the issue raised by Daisy, which I have already spoken to. Now, then, there is an aspect of Kevin's question that ties in with Kageni Catherine's question on marking schemes. Zadok, you may speak to this, the issue of marking scheme.
Okay, can you hear me?
Yes, yes.
Okay, now currently it's a council policy not to release marking schemes to the candidates, and there are reasons why those marking schemes are not released, and generally international standards do not allow us to do that. Apart from that, council is working towards maybe, you see, like today, having engagement like this where you can give feedback to candidates on what was expected of them from that marking. But we are trying, maybe going forward, we will be addressing issues like coming up with the question per question analysis that we can share with students when they are preparing. So maybe we will consult with the council to see if we can share the one for November, the question per question analysis for each unit, which students can actually go through and see what was expected of them in each of the questions that the students attempted. I think that would be maybe trying to meet the student somewhere. But in terms of sharing the marking schemes, I don't think that council will be sharing those marking schemes anytime soon.
Thank you very much, Zadok, for your response. But I need to point out, maybe Zadok has pointed out the question per question analysis. I need to point out that maybe Zadok, you're not aware, the question per question analysis based on the November examination feedback, November 2025 examination feedback, this analysis was actually shared with the school, and the school actually has access to them. And I want to believe that if your leaders, the students governing body, engages with KSL, KSL should be able to share that, because the whole reason, the whole idea as to why that was shared was for purposes of feedback. Markers gave feedback. Council wanted to give the school a feedback in terms of how did candidates respond to each of those questions. So as if the school shares that, when the school shares that with the candidates, as you revise maybe for the November 2025 examination, and you have access to the question by question analysis, then that should be able to guide your revision very much more productively, because then you'll be able to see what is it that Marcus pointed out, what is it that Marcus pointed out as having been best performed in terms of approach, and worst approach for that each of the particular questions in the entire 9 units, the entire set of the 9 units. And just tied to that, Kageni Catherine had spoken to marking schemes, availing marking schemes shows goodwill from council. I will tell you, Catherine, that there is goodwill. Goodwill is not just demonstrated by availing marking schemes. In the university, you didn't get marking schemes, but I doubt if you doubted the goodwill of your lecturers at the university. I have a background in the university, and I don't recall, for the entire time I taught, I don't recall any candidate ever requiring a marking scheme from me. So it is not about, and same as NEC, those of you who studied locally, of course I know most of us studied locally, KCP, KCSE, you didn't insist that NEC avails marking schemes to show goodwill. You studied, passed your exams, and then you really, goodwill of NEC was not demonstrated by availability of the marking scheme or not. So what I can tell you is there is goodwill. Even this very forum, this engagement with you as a critical stakeholder demonstrates goodwill by its very nature. There is a question that came from Gataka Mary. Does CLE conduct a survey on service providers? Issues of in-betweens and discrepancies, things like that. One, I want to say that CLE is able to, get feedback. Once marking has taken place, CLE has what you call checkers. So checkers are able to go through each of the papers, each of the scripts, each one of them for the entire, from paper 1, ATP 100 all the way to ATP 108. All scripts marked are checked. And from each of them, the checkers pick out any mistake. Could they be arithmetic? Could they be lack failure to maybe probably mark a page or anything? And when that happens, when those issues are raised, the papers are sent back to the markers. So there is the system, the marking, the examination system has inbuilt mechanisms to, to self-assess effectiveness, efficiency, and output of each of the service providers, and more so the markers. So yes, there is a survey, and based on the feedback from the checkers in terms of if a particular marker is probably found to maybe make a lot of mistakes, be they arithmetic or otherwise, yes, they correct them, but it also provides useful feedback for council to determine whether or not to utilize those particular service providers. So yes, that happens. So the system has those inbuilt mechanisms to address any possible shortcomings. And also very critically, something that Zadok had also mentioned, one of the other things, one of the inbuilt mechanisms is the conveyor belt marking. So you have a minimum of 5 markers per unit. So and each of them only marks one question. So that is also an inbuilt mechanism to ensure that each marker is only able to mark one question per candidate script, and then it also helps to avoid a situation where a candidate, rather a marker may have too much latitude. For example, if a marker was to mark, they have what we call the entire script marking, where one for every script, the candidate is rather a marker marks an entire script for a candidate. So there are so many other inbuilt mechanisms which we are not able to discuss at this forum. But also more importantly, when we shall be able to engage about a week before examination in November, we will be able to speak to some of these things much more specifically than this particular forum. I've also seen, and then that ties to the question on the platform where somebody's a colleague is wondering why KSL lecturers should not be the ones marking the examination script. Really, it is if the question, I remember the course outline has come from KSL. So once the KSL lecturer, there is a possible inherent conflict. I'm not saying they are conflicted, but there is a possible inherent conflict. If marking was to be done by them, by lecturers at Kenya School of Law, I think our focus, I think we may be pushing our focus to the wrong direction. Our focus should be the teaching, as the teaching been done in terms of the scope of the syllabus has it been covered. Once the scope of the syllabus has been covered, then it does not matter who sets, it does not matter who examines, who grades your scripts. It was never a concern at KCP level. It was never a concern at KCSE level. It was never concerned, those of you who may have gone through the 7-4, the 7-4-3, it's called the 7-4-2-3 system. It was never concerned at that level. It was never, it is only at the university level where the person who sets your exam is the person who marks. But really, it does not matter. If you have prepared, then you will pass irrespective of who sets and who marks. This year, this last financial year alone, Council gazetted nearly 3,000 candidates. That speaks to about nearly 3,000 candidates passed their exams, and they passed their exams based on the same standard conditions that you are expected to be subjected to. So really, colleagues, we should not be so much unduly worried about the setting and the marking. All I can assure and guarantee you is that they are done professionally, they are done based on international standards, and that speaks to the issue that there are so many people who have passed, and there are so many people right now as we are speaking. Council has processed about 400 candidates who are going to be gazetted in October, and more are still coming, and most of those are those who sat for their exams in November last year. So we should not have undue worry or anxiety, colleagues, about the examination system. It is working, it has worked, and improvements are being made to ensure that it performs even much better, to a more optimum level. Otherwise, with that, colleagues, I think we can bring it to a close. And I think when we were starting, there was an oversight. We didn't have the opportunity to give an opportunity to the Students Governing Council to introduce themselves. So at this point in time, before we close, please allow me to invite the Students Governing Council President to come on board and probably introduce the Governing Council members of the 2026 academic year. Then after that, he may make a few remarks and give a vote of thanks, and then nominate somebody to pray so that we can bring this to a close. So the president of the Students Governing Council, if you are available on call, kindly come on board. The president, if they are not there, could we have maybe their vice or somebody in the Students Governing Council? Mokwa Cheryl, are you the president? Is the president on board? Anybody, any student who is from the governing council?
Perhaps I could help you. I am a member of the Student Governing Council, but I can see Collins is here, the Secretary General. Collins, maybe you could unmute him. He's number 3.
I don't think it's me to unmute. Then you unmute on your end. Collins, please. Please come on board you could step in for the president so that you introduce your colleagues and then make a few remarks and then probably give a vote of thanks. Collins, please.
Sorry, Dr. Felix, this is Faith. I'm using Cheryl's device. Can you hear me?
Sorry, you're very low. I can't. You're saying you're who?
This is Faith, the Vice President of the Council.
Oh, yes,
Can
Faith,
you
please.
Yes.
Yes, you can be heard, although you are still a bit low.
Oh,
But
okay. Better?
yeah, better. Proceed, please.
Good afternoon, everyone. My name is Faith Korir, the Vice President of the Council. Receive apologies from John Lender, the President. He's unable to join us at the moment. I want to say that I am grateful to the Council of Legal Education for having this session with us, despite the pitch that we had earlier on when you were joining. The session has been well. I would like to introduce my fellow members, Collins and Muthoni. I don't know if there's any other person. Should I at least give them a moment to say a word or two? Dr. Felix?
Perhaps just their names and maybe a word, not two. We are really stretched for time. Kindly.
Okay. Muthoni?
Oh, hi again. This has been really lovely despite the initial challenges. Perhaps maybe for the next cohort that will come before us, you can have these a bit earlier. That will be my only suggestion.
Thank you so much. Thank you so much.
Collins? Can you now unmute? Okay.
Yes, good afternoon. Thank you so much for having us and giving us this opportunity to air out our issues and to clarify on all the questions that we had. And I hope we'll also get a chance to do this again as we get near to the exams. Thank you so much. And sorry, I'm Collins Kaberia, the Secretary General of the Student Governing Council.
So much, Collins. Thank you so much for your feedback.
Okay, Dr. At this moment, I don't think I have anything else to say other than I really hope that you will get a recording. We will get a recording of this session and the slides as well. Otherwise, mine is to just thank you for creating this opportunity and this engagement session. We hope to have at least 1 or 2 more before we sit for the examination. With that, I wish all of us the very best even as we prepare. And once again, thank you to the Council.
So much, Mokua, and thank you so much, Kaberia, for your feedback. And for us, from the council, we also want to take this opportunity to wish you the very best. We look forward to welcoming you as our younger colleagues into the profession. The role of council is merely facilitatory, and we will be able to play that role effectively so that we are able to facilitate you appropriately to get admitted into the profession. Just to give you the assurance, the issue that Collins has raised, you hope that we will have another one. Yes, there will be another one. Just about a week before the first week of November, most probably, we shall have an engagement, the final engagement with this year's cohort, and that one will be a blended session, both physical and virtual engagement, and it will most likely take place at the school's premises, one of those halls. So yes, it will happen, and it is just meant to ensure that we have that continuous engagement for feedback, as well as for purposes of the fact that it is in our interest as a council, and also in your interest as our key stakeholders in the ATP examination process, to ensure that we have these continuous engagements for purposes of improvement of getting feedback and improving the system, because our role is as a public body is to ensure that we improve, we ensure we produce, or rather we undertake our tasks in a manner that satisfies public policy and in line with the constituting act. Otherwise, thank you so much for creating the time and joining, and we wish you the very best of luck. And allow me to request Gataka Mary to give us a closing prayer so that we can be able to bring this to a close. Mary, please.
Thank you, Dr. Felix, for this engagement. We look forward to the next one. And shall we pray and close the meeting? Father, in the name of Jesus, we thank you for this afternoon. Thank you for the engagement that we've had. Thank you for the presence of CLE in this process, and for them taking their good time to just come listen to our issues and just put them into context and show a lot of goodwill and clarify what as students we've been grappling with. Thank you even for the fact that we've been able to give our feedback and got an appropriate response. My God and my Father, even as we prepare, we pray that you'll align us and keep us into correct order so that we will succeed and everybody will be happy at the end of it, and we shall glorify and honor your name. Thank you for everything that we are. We surrender and submit to your authority and pray that your favor, your goodness, your mercy will follow us in everything that we do. We pray this, trusting and believing in Jesus' name. Amen.
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 Lile.
Amen. Thank you.
So thank you so much, colleagues. And I take note of the fact that Gataka Mary has pointed out that there is goodwill on the part of council, which initially she had indicated may not have been there. Thank you so much. On a light note, have a good evening. And I want to wish you the best as you have this final stretch of your preparation during this final term of your studies. All the best, and may God bless you. Good afternoon, colleagues.
Thank you, Dr. Good afternoon.
Thank you. Good afternoon.
Thank you very much.